At my firm, it's my team that does a lot of the product liability cases. And of course, in a product's case, you're generally dealing with a design defect or a manufacturing defect. And to prove your case, you will generally have lay testimony, the plaintiff or someone who saw the incident, and an expert. But these days, that's often not enough. People watch CSI, people expect some kind of scientific proof, something more than mere words, to show that the design defect that you contend existed really did exist and really did cause the injury to your client. And that raises the question about whether to conduct testing. And I can tell you that in the cases that we've dealt with, the specific facts and circumstances of each case will help determine the answers to those questions. Dan Mann, who has tried a lot of cases with me, is going to talk to you about a few examples, and I'll get up and talk about one myself.
The first case I want to talk about is a case called Joseph. When we got the case, we were told that it was a case involving a house fire. It was an absolutely tragic case. Charisse Joseph was taking care of her two little brothers and her daughter, Rayana. Charisse, when the fire started, saved Malachi, ran back into the house, and she was unable to save herself or Mikkel. They died. Rayana suffered an absolutely devastating injury, a burn injury, a brain injury, as a result of a loss of oxygen. We got this case about a year after the fire occurred. And all we knew is that there was a heater. The client remembered that the heater was manufactured by a company called Lakewood. And we went into the house, which had been abandoned for over a year. What we found was the heater in a pile in the floor. So we now had a case where we had the heater, we obviously had damages, and we needed to do further investigation. Well, we shipped the heater out to an expert. One of the things that experts look at in heater cases are signs of electrical activity. So what the expert found was he found some electrical activity in the heater in the form of arcing and melting. So at least we knew we were past the first hurdle in establishing some sort of a theory against the heater manufacturer. Okay, this is arcing damage, and arcing is a sign of electrical activity. And this is arcing damage that were on wires that led into a rotary switch. Okay, so this is the on-off switch for the heater. This is from an exemplar heater. You know, one of the most important things in any product's case, as soon as it comes in the door, you have to buy exemplars. I think I bought about 25 heaters for this case. So it's one of the most important things in terms of in any product's case, and it will pay off in the end. So that's something I can't stress enough. So now we have some part of the heater where there was electrical activity inside. We also did something called scanning electron microscopy. SEM testing actually looks at the molecules that are present. And what we have here is something called the high limit control contact. And it's a little switch that when the heater gets too hot, is supposed to disengage and pull apart. And what we learned when we did the SEM testing is that that high limit switch was trying to pull apart and it couldn't. It was stuck, which is further evidence that the heater was overheating and that this switch was trying to cut the heater off and it was running away and it was overheating. It's important in these types of cases to always be thinking about what the defenses are. Predictably, in a case like this, there's going to be a defense that says, well, we make this heater, we construct it of this very special type of plastic that doesn't catch fire. So the next type of testing that we did was something called temperature testing. Now, what you're going to be looking at here is a shaft that was inside of the switch. We had an admission by the corporate designee that arcing damage can result in temperatures over 2,000 degrees. So what we wanted to do was we wanted to catch something on that heater on fire at a temperature as far under 2,000 degrees as possible. But we weren't done, because remember the exemplars that I talked about. What we learned when we took the exemplar apart, and this is an exemplar that the manufacturer had, it showed signs of overheating in the exact same fashion that we contended. It had already been exposed to heat that it shouldn't have been exposed to. When you're doing testing, you have to think about a lot of things. First of all, you want to do testing to help you prove your case. You want to do it to create risk and exposure for the defendants. And you want to do it to teach the jury. And at every step along the way, you need to be thinking about all of those things. Alan's going to talk about the Wilkerson case and the testing that we did in that case.
That's a pallet truck. A pallet truck is a piece of material handling equipment. It's a lot like a forklift, and it's governed by the same ANSI standard, B56.1. When you hold the handles, there's a little rotating lever. And if you move it forward, that's how the truck goes forward. If you move it back, the truck goes in reverse. And if you want to use the thumb controls to brake the truck while you're going forward, you just quickly move it into reverse, and the truck will slow and stop. That's called plug braking. This is an area of the warehouse that depicts the main aisleway where our client, James Wilkerson, was operating his pallet truck, intending to head toward that T intersection and make a left in order to pick up a box. And he tried to do, when he got to that T intersection, what he had done a million times before. Put him in reverse and slow his vehicle so he could make his turn. And he tried to do it once, and he tried to do it twice, and he tried to do it 3 times, and then he ran into the rack and suffered devastating injuries to his abdominal region. The employer and a maintenance company that we sued brought people down to drive the truck, and it operated fine. No one could duplicate, no one could replicate what happened to Mr. Wilkerson. We knew it would be very dangerous to go to trial just based upon Mr. Wilkerson's testimony. We engaged in testing, and we had our pallet truck expert and our accident recon expert take the truck that we all collectively purchased and did testing. And we invited all the defense lawyers, all of their experts. We invited them to do their own videotaping. So let's look at how the truck normally works. And we're seeing our expert operate the pallet truck in forward and reverse, and that's the way it's supposed to work. What happened was, at this particular test, we learned something. Okay, stop. See that? There is a strobe light on the front of that pallet truck that nobody, not we, not the defense lawyers, not anyone, paid any attention to during all of the discovery that was taken in this case. There was only 1 or 2 questions asked about it over a period of years. And you know what we learned? Whenever that strobe light was attached and hooked up to the pallet truck, and you move the thumb controls forward to 90% of full throttle, and then tried to reverse the plug braking failed every time. Every time. And every defense lawyer saw it, and every expert saw it. So now we knew that there was at least a scientific, incontrovertible explanation for a plug braking failure. And here's what a plug braking failure looked like. And it's at that cone that he's trying to brake, and you see his hands moving, and nothing's happened. And that allowed us to prove, through our accident recon expert, that our client had 2.1 to 2.9 seconds. That's all to react from the time he first began to brake until contact with the rack.